Timothy Cook, CR 53420.
Thank you.
All right, good morning.
Top of the morning.
All right, on February 1st of this year, you were arrested and charged with trespassing and resisting arrest. Do you understand the charges?
No, I do not understand the charges against me or the nature and cause of the actions against me as well.
Okay, so do you need me to read the ticket to you?
No. I do need to demand for a jury by trial.
Denied?
Denied?
Yeah,
Okay.
under Nevada law, you don't get a jury trial.
An issue of fact shall be tried by a jury if a jury trial is required under the Constitution of the United States or of the state of Nevada or by statute.
Does this court intend to try me under a criminal action or a civil action?
It's under the Nevada revised statutes. This court's not trying, this court is not, it's under Nevada revised statute. Did you read the ticket? It's all there.
I just wanted to know if this court was intending to try me under a criminal action or a civil action.
It's criminal.
Criminal?
Yeah.
Because the Constitution grants me the right to a trial by jury
No.
with all criminal actions.
No, it does not. There are factors that, City, can you reference the North Las Vegas case that went to the U.S. Supreme Court? You guys remember the name of that case? There was a case from this court that went to the U.S. Supreme Court. They said misdemeanors are petty offenses and they're not entitled to a jury trial.
Your Honor.
So, but anyways.
No disrespect, Your Honor. Yes.
All right, listen, Mr. Cook.
Yes, sir.
What? Blanton, okay. Today is the initial arraignment. I ask the questions, you don't ask the questions.
All cases in which there may arise a question of validity of any matter under this chapter shall be advanced as a matter of immediate public interest and concern and be heard at the earliest practical moment.
In my process of doing the arraignment, I could hold you in contempt and I'll incarcerate you for contempt. Do you understand that?
Your Honor, I'm simply trying to grasp an understanding of the nature and cause of the actions against me.
If you have certain questions about the understanding of the charges, I don't mind reading the charges to you. But I need to make sure that you have a copy of the ticket. I need to make sure that the spelling of your name is correct. That your date of birth of August 31st, 1998, is that correct?
That was the day I was born.
What's that?
That was the day I was born.
Okay, all right. Okay, and the name spelled correctly is Timothy Cook.
Cook is the tribe I come from. My family calls me Timothy.
Yeah.
When the defendant is arraigned, the defendant must be informed that if the name by which the defendant is prosecuted is not his or her true name, the defendant must then declare his or her true name or be proceeded against by the name in the indictment, information, or complaint. If the defendant gives no other name, the court may proceed accordingly. But if the defendant alleges that another name is his or her true name, the court must direct an entry thereof in minutes of the arraignment and the subsequent proceedings on. The information, indictment, or complaint may be had against the defendant by that name, referring also to the name by which the defendant was first charged therein.
As a natural person, that's my name.
Listen, we're not going to do this. Okay, you're going to follow my procedures today.
Am I under your jurisdiction,
Oh,
sir?
yes, you are.
Is there a signed contract?
No, okay. Listen, I told you before, if you interrupt me with these silly questions, I can hold you in contempt up to 25 days in jail. Do you want that?
Your Honor, I wish not to do that. I'm simply exercising my rights.
No, you don't have a right to forestall this proceeding today.
Your Honor, if I may, no disrespect, it says inside Article 1, Section 3 of the Nevada State Constitution, the right of trial by jury shall be secured to all and remains inviolated
Okay.
forever.
All right, officers,
Your
we're
Honor.
in custody today. I've already answered your question about
I want,
the jury trial.
sir, I'm not resisting. I'm not resisting. I wish not to be in contempt. I wish not to be in contempt. Your Honor, I haven't done anything wrong.
Yes, you keep interrupting me, and
Sir, I want to have an understanding. I don't
I've already
understand.
answered the question about jury trial. You don't have a right to jury trial.
Your Honor, you uphold the Nevada State Constitution because in Article 15, Section 5, it says that.
Okay, so we're going to recess court right now.
There's no proper due process. No proper due process. Record means information which is inscribed on a tangible medium or which is stored on an electronic or other medium and is retrievable in perceivable form. Proper due process.
That Mr. Cook became disruptive in the court process, the court proceedings. He attempted to take control of the court proceeding. And that he began to resist the bailiffs in the courtroom. I gave warning several times that I'd be asking questions so we can get through the initial arraignment. He refused to cooperate with the court. So whereas in Nevada Revised Statute 22.030 declares that when contempt is committed in the immediate view and presence of the court or judge and chambers, it may be punished summarily, for which an order shall be made deciding the facts as occurring in such immediate view and presence. Judging that the person proceeded against is thereby guilty of contempt, and he's punished as there described in. This has happened on the 3rd day of March, 2020. And the individual's name is Timothy Cook, who was a party to the proceedings. And he was disorderly, contemptuous, and had insolent behavior towards the judge while he was while in court engaged in judicial duties. He conducted breach of peace, boisterous conduct, and he became violent in a manner when the bailiffs attempted to put him into custody. Whereas in such conduct would be in court, derogatory to the authority of the court. He had agreed to the justice regarding immediate vindication by the court to preserve order and respect based upon the findings. Cook is hereby guilty of direct contempt. Okay, is therefore is ordered, judge and decreed that the contender is hereby sentenced to the following punishments: imprisonment for 3 days. Okay, so Madam Clerk, what we're going to do is we're going to exonerate his bonds today. I'll go ahead and set bail at $10,140. And today is Tuesday, so we're looking at, let's go ahead and schedule him for in-custody session on Thursday.
Like I said, I had he was just fine with me. I had a nice normal conversation with him. The city has made an offer and he said he was going to accept it once we got to it.
To do his credit time, sir, both counts if he wanted to resolve the case today.
Okay, so he's been, and how long was he in custody before? Was it over there?
It was 1 day.
Okay, so he's got 2 days jail and 2 days credit. He does have 1 more day to serve on his contempt charge. All right, so, how are you gonna plead the charges with credit time served?
Yeah, you can explain that to me so I have, like, know what that means.
Okay.
This part that you're.
Any fines, you don't have any classes, there's no suspended, the case is never closed, you get out and you move on to life.
Okay,
If a plea of guilty or guilty but mentally ill is made in written plea agreement, the agreement must be substantially the form prescribed NRS 174.063. If a plea of guilty but mentally ill is made orally, the court shall not accept such a plea or a plea of nolo contendere without first addressing the defendant personally and determining that the plea is made voluntarily with the understanding of the nature of the charges and consequences of the plea.
okay, so you have one more day.
I'm sorry, Your Honor.
How has he not pleaded the charges?
No contest, he pleads back to basic.
Okay, that's it. You'll be out by tomorrow night, okay? No, we already saw it on, right?
Yes.
Okay, John Picardo, CR 104-220.